36, huh? Serial number 36. I request next week. Huh? You know? Serial number 36, my lord. May I request next week, my lord? I informed the other side. Manavendra Reddy, sir, I have already informed. They have to be here. Otherwise, also we'll adjourn, no problem. Please. Yes, please.
My lordship, serial number 46, it may be taken on next Tuesday, my lord.
You
I
other
have
side,
informed.
Yes, sir.
46.
46 time for the claimant.
46.
For time for the claimant.
date
Any
may be
date
fixed, my lord.
Fixed, my lords, because
46. ನೀವು ಯಾರ ಪರವಾಗಿ
I am for the claimant.
I am for the appellant, my lord.
ಯಾವ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಪ್ಪ?
Respond number 1 to 3 in both the appeals.
ಮಿಸ್ಟರ್ ಶಿವಾನಂದ್ ಪಾಟೀಲ್.
Yes, yes.
Who is requesting for adjournment?
I am.
For insurance from
Insurance
company
company
appeal is
ಯಾರ
there.
ಪರವಾಗಿ?
Behalf of Kayak Matsar and Sudarshan M.
Huh?
Behalf of Kayak Matsar and Sudarshan M.
ಸುದರ್ಶನ್ ಹೆಸರಿಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ಇದೆ, my lord.
Connected matter.
Connected
appeal.
matters, sir.
Connected appeal, company appeal.
ಹಾ 46 at the request of learned counsel Shri Sudarshan M. Release this matter on 23rd of October.
My lord, 23rd to 25th, I am out of station for personal reasons.
28th.
28, please, my lord.
Yes.
My lord, serial number 36, my lord. 38.
Sound ಕಡಿಮೆ ಮಾಡ್ರಿ. Yes.
Serial number 38, my lord. RFA. Time for the aviator, my lord. They have served the copy yesterday. I need some 2 weeks time to file my statement of opposition.
38. No, we don't adjourn the matters unless the other side is here. If when the matter reaches, you can mention.
Yes, ma'am. Please, I'll mention when the matter reaches.
Number 44, Your Lordship. I am the proxy counsel appearing on behalf of respondent number
You are for the respondent.
I appear for the appellant.
44.
44. I am agree.
You are for the appellant.
Appellant number 1,
Respondent. You are asking for adjournment.
please.
Serial number 44 at the request of learned counsel for respondent. Release this matter on 23rd of October.
Obliged.
Yes.
Non-compliance of office objection for first time. Serial number 1, additional government advocate.
Appear for the appellant, my lord. Place a week's time, my lord.
2 weeks time or
Please. Grateful.
2 weeks at the request of learned AG, learned government advocate for complaints of office objection.
Serial number 2, Jidage Kailas C.
weeks time.
Huh?
I will comply after subject weeks time.
The week's time is granted. Yes.
Complaints of office objections for second.
Which time?
Serial number 3, Subhas Mallapur.
A week's time. I was week's time.
The week's time. Yes.
Serial number 4, Veerangoda Mali Patil.
Pay for a week's foundation, my lord, for compliance of officer.
Same order.
4 to 8, my lord. All are connected.
Yes.
Okay. Serial number 9, government advocate.
9 and 10 also, my lord. 2 weeks time, my lord. Valuation slip I had to go.
Finally, 2 weeks time is
Please.
granted. At the request of learned government advocate.
Serial number 10,
Same.
Same order.
serial order. Serial number 11, Nitesh Padiyar.
Is this matter after service of notice on the respondent?
Serial number 12, Ravi B Patil.
Order sheet, please. Four weeks is granted to the appellant to furnish paper books.
Serial number 13, Vinayak Apte.
She got 1 week, my lord. Paper book are ready, my lord. I will get it filed by
Huh?
next week.
Paper books are ready, my lord.
Ready.
I will
Learned
file
counsel for the appellant submit that the paper book is ready.
1 week times.
Full stop. A week's time is granted to the appellant to file the same.
Yes.
Serial number 14, Mahantesh Patil.
Mantesh Patil,
Serial number 14, Mahantesh Patil.
a week's time is granted to the appellant to 2 weeks' time is granted to the appellant to furnish correct address and to take steps for service of notice on respond number 2.
Serial number 15, Manmendra Reddy.
ಏನಪ್ಪ ಅಂದ್ರೆ objection.
Serial number 15, Manmendra Reddy.
We caveat some objection with regard to filing of a caveat.
Release this matter on 21st of October. Full stop. Office is directed to show the name of learned counsel Sri HR Malipatil for the respondent. ಅವ್ರು ಬರ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ. ಯಾಕಂದ್ರೆ ಅವ್ರು ಹಾಕಿದಾರಂತೆ ಬಟ್ that party's name is not found in your cost title.
I'll check.
So let us find out, let him come.
Serial number 16, Virangoda Mali Patil.
My lord, the only office objection is regarding non-filing of the award, my lord. I have sought for dispensation. Non-filing of award. I have made a council submission regarding under order 41 rule 1, copy of award not necessary. Under order 41 rule 1, copy of the award not necessary.
Not necessary.
No. Once it is ready, I will file it, my lord.
ಹಂಗೇಳಿ not necessary.
Illa, it is necessary, my lord, but only after the award is ready, I will file it.
Learned counsel for the appellant submits that the appellant will furnish certified copy of the award as soon as it is received.
My lord, in connected matter, lordship has already granted stay.
Huh?
Connected matter, lordship has already granted stay, my lord. These are the Atti government's matter beneficiary appeals. For
So similar orders.
similar orders. For R1, no emergent notice, my lord. For R2, government.
Same. As in MFA number 2027775 of 2022. Yes.
Please.
Serial number 17, KM Ghate.
Paper. Respondent number, my lord. 234, my lord. In this matter, my lord, Jilla Panchayat has to file the report of the, my lord, ADLR. But some of the, my lord, land is, my lord, already utilized by the Jilla Panchayat. They are not sent the proposal to us for acquiring the proceeding. We are requested the, my lord, Jilla Panchayat to submit the, my lord, proposal.
Which is the
But they are not submitted.
which is the order? Annexure A na?
Annexure, my lord.
Annexure A.
Yes. Last para, my lord, page number 26, my lord. Sorry. Para 7 and 8.
Hyper for answer.
Yes.
I'm filing the report, survey report. Survey ಮಾಡಿದೀವಿ.
ಹಾ?
Survey ಮಾಡಿದೀವಿ.
ಏನ್ ಮಾಡಿದೀರಾ?
Survey ಮಾಡಿ.
ಸರ್ವೆ ಮಾಡಿ?
ಈಗ ಮಾಡಿದೀವಿ survey ಮಾಡಿ.
ಸರ್ವೆ ಮಾಡಿ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, value of the land has to be determined by the respond number 3.
ಹಾ.
ಅದ್ರ ಪ್ರಕಾರ ನಾವು ಏನ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್
ಬೀದರ್.
ಬೀದರ್
ಹಾ.
ಅವ್ರ ಲ್ಯಾಂಡ್ ವ್ಯಾಲ್ಯೂ ಏನಾದ್ರು ಹೇಳಿ ಕೊಟ್ರೆ ನಾವು
First, they have to send the proposal to us, my lord. This is already utilized by them.
March 2022 ಆರ್ಡರ್.
ಇನ್ಫ್ಯಾಕ್ಟ್
ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಇದರಲ್ಲಿ ನಾವು ರೀಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿದೀವಿ ರೋಡ್ ರೀಡೆವಲಪ್
ಅದೇ ಯಾರನ್ನು ಹೇಳೋದಿಲ್ಲ ಕೇಳೋದಿಲ್ಲ, ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ ಲ್ಯಾಂಡ್ಗಳ ಮೇಲೆ ರೋಡ್ ಫಾರ್ಮ್ ಮಾಡ್ಬಿಡೋದು,
ರೋಡ್ ವಾಸ್ ದೇರ್.
ಆಮೇಲೆ ಅವ್ರನ್ನ ಅಲ್ಸೋದು. ದಿಸ್ ಇಸ್ ನಾಟ್ ವೆರಿ ಅನ್ಕಾಮನ್. ದಿಸ್ ಇಸ್ ದಿ ಕಾಮನ್ ಫೀಚರ್ ಎವ್ರಿವೇರ್. ಯು ಥಿಂಕ್ ಯು ಆರ್ ದಿ ಲಾ, ಯು ಕ್ಯಾನ್ ಡೂ ವಾಟ್ ಎವರ್ ಯು ವಾಂಟ್. ದೇರ್ ಇಸ್ ನಥಿಂಗ್ ಕಾಲ್ಡ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಕ್ಟ್. You don't have to follow anything.
Lordship, she annexed her notes. ಅದರಲ್ಲಿ the tender was called for reconstruction of the road.
Huh?
Tender was called for reconstruction of the road. ಅದು
ಹೌದ್ರಿ, ಪ್ರೈವೇಟ್ ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ ಹೆಂಗ್ರಿ ಮಾಡ್ತೀರಾ? Is it your property?
No, no.
Then how did you proceed to form the road without acquisition? And this order is passed in March 2022. ಇವಾಗ ಏನೋ ಸರ್ವೆ ಮಾಡಿದೀವಿ, ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
That road is formed by notes KKRDB funds ಅಲ್ಲಿ ಮಾಡಿದ್ರು.
By order dated 4/9/2024. This court had recorded this submission made on behalf of response number 5 and 6, that a survey will be conducted with the assistance of the revenue officials to ascertain the extent of land used for the purpose of formation of road on the property belonging to the petitioner. Full stop. It was therefore directed that such report shall be filed before this court, while also directing that the respondents shall take necessary action for compliance with the directions issued by the learned single judge in paragraph number 8 of the order. Full stop. Accordingly, next paragraph. Learned counsel for respondents number
5 and 6.
4 and 6.
5 and 6.
5 and 6.
Five.
Correct ಮಾಡಿದ್ದೀನಿ.
That one.
5 and 6. Has today filed a memo along with a survey report showing the extent of land utilized for the formation of road. Full stop. Learned counsel would however submit that the assistant commissioner, Bidar district, we'll have to determine the compensation payable. Full stop. Next para. If that is so, the fifth and sixth respondents are required to immediately forward the report along with the request from respondents number 5 and 6 to the assistant commissioner, for determination of compensation. Full stop. The respondent assistant commissioner Bidar is also directed to forthwith take action having regard to the directions issued by the learned single judge in paragraph number 8. Full stop. It is noticeable that the order was passed on 17th of March 2022 and the respondents have been lax in their response to the directions issued by the learned single judge. Full stop. Therefore, 4 weeks time is granted to the respondents to place before this court information regarding the compensation determined by the assistant commissioner. Full stop. Next para. Release this matter on November 25th.
Respondent correction. Number 18, DP Ambekar.
Here for the number 2, my lord, I will take notice for R1 also, my lord. I already filed the affidavit.
Huh?
I already filed the affidavit, my lord, of
Ah.
this number 1. But I will take notice for R1.
Complaints, ah.
Yes,
Complaints.
complaints, my lord. What happened, my lord, this on court, the learned single judge, my lord. Take your lordship, my lord, page number 26, my lord. This is the, my lord, election of president and vice president of the, my lord, Talaka Panchayat, my lord. First day, my lord, there was no quorum, my lord. For that is the reason, my lord, if there is no quorum, next day has to be conducted, the election. There is a direction to the returning officer to conduct the next date of election. That is, date is fixed. Accordingly, date is fixed, my lord. But that day, what happened, my lord? There is a galata among the members, my lord. That is not conducted the election on that date. So immediately another date is fixed, they completed the proceedings. But the contention of the complainant is that, my lord, when the court, this court directed to fix the next date, on that date, my lord, the returning officer not conducted the election.
Adadmele election aita.
ಮಾಡಿದ್ದಾರೆ, announce, yes.
Then
Lordship, I have
what
not
are you
served.
complaining of?
Copy is not yet, so we'll go through and
But it is-
date may be fixed.
Copy is already given.
Learned government advocate submits that an affidavit of the ಯಾವ್ದ್ರಿ ಅಸಿಸ್ಟೆಂಟ್ ಡೈರೆಕ್ಟರ್ ಮಿಡ್ ಡೇ ಮೀಲ್ಸ್ ಹಾಕಿದೀರಾ?
ಈ ಅಸಿಸ್ಟೆಂಟ್ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್, my lord.
ಹಾ?
He is the returning officer.
ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್.
ಹೌದು. Last title, my lord, of the complainant, my lord, that is returning officer of Taj Sultanpur, Ram Panchayat.
ಇದು ಲೇಟೆಸ್ಟ್ ಇದು. ಮುಂಚೆನೆ ಹಾಕಿದ್ರಲ್ಲ information.
Yes, it is already filed, my lord.
It was filed on 8/12/2023
Yes,
itself.
that is already filed, my lord.
Same thing you again filed.
No, there is a direction, this on court, my lord.
Ah.
What is the deputy commissioner has taken action against you for not conducting the election on that day? But when this on court is directed
By
me,
which order?
at, 4/9, my lord. 4/9.
Once the proceedings of 4/8/2023 were challenged in WP number so and so, and order passed regarding the same, the direction to conduct election ought to have been by redoing the process in entirety.
Redoing and the other, redoing question of doesn't arise, my lord, here. Because, my lord, the stage, my first stage, my lord, after the, my lord, there is a calendar of events for receive of the nomination and all.
Therefore, how can you file a contempt petition? If you are aggrieved that the process is not followed, you'll have to file a fresh writ petition.
We'll go through. A
Alva.
week's time may be granted.
Contempt means the officer has not followed the directions issued by this court.
Yes, my lord.
Huh? But he has filed an affidavit in the month of December itself, saying there was a direction and had fixed the date on the particular day, but due to the problem created by the members, he was not able to hold the election on that day. So he has fixed the next date and he has held the election. What is it is said in Shobha P?
Lordship,
That case has been cited again and again.
yes, my lord.
What is that?
In that particular case, my lord.
Do you have a
once-
copy of that?
Yes, my lord, I-
Judgment, please give it. ಏನು? What is the declaration of law in this? Thus, we are of the opinion that prescribed officer was justified in fixing future date for election and was right in not proposing to declare the result of the candidates who filed nomination on so and so. That is, the appellant herein, as there was no quorum in the said meeting. It is pertinent to mention that what is the law declared here?
Your lordship, and as per my understanding, my lord, as per Shobha P, my lord, the whole calendar of events has to be issued again. The election process has to be re-notified, my lord. He cannot continue with that particular notification which was earlier there because of non-existence of the
What
quorum.
were the directions issued by the learned single judge?
Learned single judges.
If you have accepted it, then that is the end of the matter. If that direction was contrary to this judgment of the division bench, then you should have challenged it.
Direction was not contrary, my lord. In fact, the direction was in view of the ratio of this judgment, my lord.
Let us see. In that way of the matter, the returning officer is hereby directed to conduct election by fixing the next date, taking into consideration the rules provided therein. In this regard, returning officer shall also keep in mind the judgment of this court in the case of Shobha P and others.
The learned single judge,
Therefore,
directed to follow the ratio.
therefore, if your contention is that the process should have recommenced, then the election held is not in accordance with. Then you'll have to file a fresh petition. He has proceeded as what he has understood is the correct position.
But at that point of my, your lord, in my humble opinion, my lord, there was an interim order also by this honorable court.
Yenanta.
That the process be stayed and until the further direction is issued by this
Aye,
honorable court,
Sorry,
need not proceed further, my lord.
correct.
But then despite that, that nomination was accepted on the next date, my lord. That's the
Okay.
reason
See,
there was
please
non-compliance.
see in paragraph number 13 of the order of the learned single judge,
Yes,
which I read out just now.
yes, my lord.
He has said the returning officer is directed to conduct the election by fixing the date.
Yes, ma'am.
Otherwise, the learned single judge should have said clearly, redo from the this stage. Adellilla. He has proceeded according to what he has understood is the correct position.
Yes, ma'am.
So therefore, you cannot complain that there is violation of the orders of the court. At best, you may get a cause of action to challenge the election itself.
Taken up in the afternoon, my lord. I may kindly pass on, my lord.
No, we'll have it next week. Please come,
Yes, ma'am.
Parkale.
Please.
Learned government advocate submits that after this contempt petition was filed, the returning officer filed an affidavit before this court on 8/12/2023, stating that although he was not able to proceed with the elections on the next date fixed, namely 22/9/2023, nevertheless, 4/9/2023, 4/9/2023, nevertheless, a next date was fixed, that is 22/9/2023, and the election to the post of Adhyaksha and Upadhyaksha of the Gram Panchayat was conducted and results were declared. Full stop. However, this court, by order dated 4/9/2024, directed that necessary affidavit in the light of the observations made in the said order shall be filed by respondent number 1. Full stop. Accordingly, another affidavit was filed on 4/9/2024. In the said affidavit, the returning officer has stated that no directions were issued by the learned single judge that a fresh calendar of events shall be issued. Full stop. Therefore, the returning officer has proceeded from the stage when which the elections were halted. Full stop. Next para. Prima facie, we are of the opinion that the returning, respondent returning officer has conducted the elections in terms of what he understood of the orders passed by the learned single judge. Full stop. It is also a fact that the elections have been conducted and results have been declared. Full stop. Therefore, the petitioner complainant is required to satisfy this court as to how the contempt petition is maintainable. Full stop. In our opinion, if the petitioner was aggrieved of the subsequent elections, then he should have challenged the same and he could not have filed a contempt petition. Full stop. Next para. Learned counsel for the petitioner seeks for a short accommodation to secure instructions and make submissions. Full stop. Release this matter on 23rd of October.
What you also said the date, my lord, 4/9/23, my lord, not 4/8/2023.
8
ಹೌದು
4/9 ಅಂತಿದೆ ಕಣ್ರಿ ಎಲ್ಲಾ ಕಡೆ.
ಇಲ್ಲ 22/9, my lord, that is the subsequent date, my lord,
4/9
22/9.
ಆಮೇಲೆ 22/9. It
ಹೌದು.
cannot be 8.
ಅಲ್ಲ,
ಅಷ್ಟೊಂದು ಗ್ಯಾಪ್ ಇರಕ್ ಸಾಧ್ಯ ಇಲ್ಲ. Anyway, we'll see.
please, I'll take notice for R1 served ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್.
ಹಾ?
ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸರ್ವ್ಡ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. I take notice for the responder 1 also.
R1, learned government advocate starting early also takes notice for respond number 1.
Please. Right.
CL number 19, Yama L Kulkarni.
Lord, in this case, I filed a memo for retirement.
Hmm.
Sanju Kumar C. Patel advocate, I have filed a memo for retirement, Lord. My name may be deleted. Already since Hema L. Kulkarni has filed a wakalat on behalf.
ಯಾರು?
Hema L. Kulkarni already filed an wakalat, NOC wakalat.
ಕುಲಕರ್ಣಿ ತೋರ್ಸಿಲ್ವಲ್ಲ ಹೆಸರು?
Hema LK ಅಂತ.
19. ಹೇಮಾ ಕುಲಕರ್ಣಿ.
She has filed a wakalat.
Since learned counsel, Srimati Hema L. Kulkarni has filed NOC wakalat on behalf of the appellant, the name of learned counsels, Sri Sanjeev Kumar C. Patil may be removed from the cast list. ಅಷ್ಟೇ ಮುಗಿತಲ್ಲ.
CL number 20, Baswaraj Yakreddy.
Lord, I appear to undertake to appear for the respond number 1, my lord.
Learned counsel Sri
Venkatesh Mallavadi.
Venkatesh C. Mallabadi
Yes,
undertakes to appear for
respond number 1.
respond number 1. A week's time is granted. For filing power on behalf of respond number 1.
Please.
Yes.
CL number 21, Sheshadri Jaishankar. CL number 21,
A week's time is granted to the appellant to take steps for service of notice on respond number 2.
CL number 22, Liaquat Farid Ustad.
I appear for the
Week's time, my lord. Days before. A week's time, my lord, to ascertain the, she has served a endorsement. He has filed affidavit, my lord, and along with that, there is endorsement. I will verify it and. make
compliance is
submission.
already filed, my lord, along with the affidavit. a representation was required to be considered. My lord, we had considered it and we have issued an addendum.
Rejected.
Lord, I will verify with my client, my lord. Kindly have it next week, my lord.
ಲಾಸ್ಟ್ ಟೈಮ್ ಹಾಕಿದ್ರಲ್ರಿ ಎಷ್ಟರಿ ಟೈಮ್ ಕೊಡ್ಬೇಕು ನಿಮ್ಗೆ?
ಇಲ್ಲ ಸ್ವಾಮಿ, last time.
ಹಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, last. They have served me
On 14th, I have filed, my lord, the affidavit.
yesterday itself.
Compliance report. Compliance affidavit
Complaint of-
has been filed on behalf of respondent number,
Respondent number, my
Three.
lord, 3.
respondent number 3. Full stop. However, learned counsel for the petitioner complainant seeks for a short accommodation to secure instructions and make submissions.
Much.
Full stop. Release this matter on 23rd of October.
Serial number 23, Ganesh Subhash Chandra Kalaburagi.
Today's time for compliance of authorization, serial number 7 here. I have to file an application for permission to.
Week's time is granted at the request of learned counsel for the appellant for compliance of office objection.
Yes.
Serial number 24, hearing on IA, Santosh Kumar B. Biradar.
It's a double murder case, means.
Huh?
It's a double murder case. All the appellants have been convicted by the trial court.
2017.
Yes, means.
My lordship, it's almost 12 years, so kindly be taken for final hearing.
And then
Second week of November, date may be fixed, my lord.
I appear for accused number 5. List these matters for final hearing. Yes,
Final.
When do you want?
21
Second
of-
week,
Huh?
second week of November. On 11th, from 11th.
11th of November. ಆಗ್ಬೋದಾ? If it is possible, 6th of November, 5th to 6th of November.
11th will be. 11th would be better.
11th of November.
Serial number 25, SS Ahalalli.
The appellant is a wife, my lord. There is a delay in filing the appeal, my lord. Find it is.
I have filed the objections today, my lords, but before that, my lords, I would want to bring it to honest notice. After the judgment having been passed.
You had filed the MC petition for dissolution of marriage.
Yes, my lords.
And the marriage is dissolved.
Yes, my lords. It was dissolved. And on 8/10/2019, that is even prior to the filing of this.
See,
is
in
already
these matters, ultimately matters have to be decided on merits only. It cannot be decided, the appeal cannot be dismissed on the ground of delay.
No.
Possible.
Yes, my lords. But my lords, since delay, there was delay on 8/10/2019.
So got married.
I have married and I have a child. My lords.
ಏನ್ ಮಾಡೋದು? ಈ ವಿಷಯದಲ್ಲಿ ಬಹಳ ನೀವು you have to be very clear and very industrious to see that the appeal is filed within time. His marriage cannot be declared as illegal. What can be done now? Lord, anything it can be molded in at least, Lord. Aste, only for the purpose of other benefits we can consider aste. Ad bitre ಇನ್ನೇನು ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ ಅದು. Yes, it can. You can get your clients.
Yes.
You please sit across the table.
Certainly.
You use your good officers.
Yes.
Try to see and settle the matter amicably. And they have 2 children. Ade.
Now custody file ಮಾಡಿದ್ವಿ. Anyways, we'll sit across and work out some remedy.
ಇನ್ನೊಂದು ಏನಾಗಿದೆ ಅಂದ್ರೆ delay is, my lord. In fact, MC, my lord, the CP was filed before the Dharwad bench. And orally it was instructed not to so precipitate the matters. Once the wife had filed before the family court Dharwad for the Not to restoration of precipitate. conjugal right. Not to precipitate. What? The divorce petition filed, husband. And at the time of passing the order in CP transfer, you have participated in the proceedings. ಇಲ್ಲ ಇದರಲ್ಲಿ ಇಲ್ಲ ನಾನು ಮಾಡಿದ್ದು ಯಾಕೆ ಹೇಳ್ತೀನಿ ಮೇಡಮ್. Why she has not filed is she did not participate. They were living together. Now they are disputing, saying that I will not precipitate the matter, and the husband also ensured that I am going to withdraw it. You don't participate in it. So he believed in it. Even, my lord, when the CPU came to be allowed by the Dharwad High Court, by that time the decree was already passed. They did not bring it to the notice of the High Court also. That's how she has been so deceived, under the impression that if she precipitate anything, this may come in the way of settlement. All these things have intervening, my lord, circumstances have led all these things. And my lord, CP.
Nodri.
Yes, so you cannot simply say that I am remarried and nothing.
No,
can
no,
be
my lords,
done.
it is not the case.
These are the
In fact,
contentions that can be raised.
In fact,
There is something to consider there.
yes, my lord. In fact, my lords, when we were together, previously I had filed a restitution of conjugal rights where the matter got settled due to the intervention of elders and well-wishers. After that, my lords, the matrimonial disputes continued. And, my lords, in the year 2016, she filed MC. Before that, my lords, what she does is, my lords, in a widely circulated newspaper, my lords, by name Vijayvani. Yes, my lord. She has a half-page article, news article against me, my lords, completely false, defaming me, my lords. I was constrained to file a divorce petition. I filed, and like
what petition she had filed?
she had filed restitution of conjugal rights. And she, my lords, almost a half a page of a newspaper article defaming, my lords. I'm a government servant. My lords, the whole idea of filing the newspaper article was to defame me, my lords, to show me or to lower my reputation in my calling. Now, my lords, so I filed a divorce petition and a CP was filed. And during pendency of the divorce itself, my lords, we were living together for some period as the court directed. From 18/1/2018, she did not leave. After 18/1/2018, this is the order sheet where the court specifically gives a.
We will condone this delay, and we will direct both the parties to try and see whether the matter can be settled.
Yes, ma'am. I have in fact strongly advised my client to settle the matter because nothing now, it would be placing the
Order on year number 1 of 2021.
In fact, it is not 523 days, lords, it's more than that. Lords, it is not 523 days, lords, it is more than that. Because delay, it is not 523 days, lords. It is because the order is passed in the month of October 2018. And according to their own affidavit, by September 2019, she was very well aware of the matter being disposed of.
You are saying the number of days?
Yes, number of days is more, lords.
How?
Because the order of order is 28/10/2018, my lords.
28/10/2018.
And the appeal is filed in the month of October 21. Even before they could take
28th of October.
Yes,
correct. Same date. 28/10/2021.
Yes, my lords. So even before COVID started, my lords, there was delay.
Irbodu. What is the total number of days you have shown?
523 months. It would be more than 1,000 days.
No, my lord. 1920. My lord, she came to know that. 3 years.
Yes.
3 years is there. My lord, she came to know, my lord, when that is to explain, that's all. But the number of days delay has to be counted from the date of judgment till the date when you file the appeal. So 3 years delay there. You are explaining it, that is different. I leave it. Nearly 1,000 days. 1,096 days. Order on year number 1 of 2021. This application is filed by the appellant wife seeking continuation of delay of 523 days in filing the appeal. Full stop. At the outset, learned counsel for the respondent submits that the number of days delay is much more than 523 days, since the impugned judgment was passed on 28/10/2018 and this appeal is filed on 28/10/2021. That is exactly 3 years after the impugned judgment was passed. Full stop. Therefore, there is a delay of 1096 days and not 523 days as stated in the application. Full stop. Next para. Nevertheless, learned counsel for the appellant submits that the respondent has violated the directions issued by this court in a civil petition that was pending consideration before this court during the pendency of the matrimonial case.
Direction, according to them, it is a oral direction is what they
I
claim. I filed my
In MC number 198 of 2016.
CP 1000002 of 2017.
CP number in CP number
1000002 of 2017. Dharwad bench.
Dharwad bench at Dharwad bench. And it was allowed on 23/11/2018. It is submitted that the said civil petition was allowed on 23/11/2018. Yenanta, so divorce petition which was filed at Bijapur was transferred to Dharwad. By this time, the judgment has already rendered. Therefore, that they did not bring it to the notice of the High Court. Note, this is how they played them.
No,
Yenanta?
incorrect,
Yenanta?
actually.
Full stop. However, the respondent did not bring to the notice of this court that the matrimonial case filed by him was already disposed of on 28/10/2018. Full stop. This itself shows that the appellant herein was kept in dark and she was not aware of the impugned judgment. Full stop. Next paragraph. Having regard to the submissions made on behalf of the appellant and having regard to the fact that the respondent herein claims to have remarried before this appeal could have been filed by the wife, this court is of the considered opinion that the matter is required to be decided on merits. Full stop. Therefore, we are of the considered opinion that the application has to be allowed and is accordingly allowed. Full stop.
I have filed objections. I have filed my objections. That may be noted.
First paragraph in the first paragraph I have said
Yes.
you have raised this objection.
And I filed my objections as well.
What formalities?
Yes.
Certainly. Delay condoned. Next para. Having regard to the observations made herein above, this court is also of the opinion that the parties should endeavor to settle the matter amicably, and therefore the parties herein are directed to make efforts to settle the matter before the next date of hearing. Full stop. Next para. Release this matter
It may be referred to mediation. There they can sit across and work out because.
ಹೋಗ್ತೀರಾ?
Yes, ma'am.
ಆಗ್ಬೋದು. Accordingly, the matter stands referred to the mediation center. Full stop. Parties are directed to appear before the mediation center on ಯಾವತ್ತು?
28th, any dates?
20, huh? I'll have to. Allah, you are still working, isn't it?
Yes, ma'am.
Huh? So you should tell.
28th, I'll instruct my party to be present. He'll be
28th of October 2024.
Yes.
Yes. Release this matter on 11th of November. Yes.
Published.
Serial number 26, Kausalgi Chandrakant Lakshman. Limits for enhancement. In case of the injury.
Huh?
Limits for enhancement in case of the injury. R1 is dispensation.
Huh?
R1 is dispensation. Injury.
Notice order ಮಾಡಿಲ್ವೇನ್ರಿ? R1 is deceased.
Dispensation. R1 dispensation.
Dispensation. ಇದು ನ್ಯಾಷನಲ್ ಇನ್ಶೂರೆನ್ಸ್.
National Insurance ಇವರು ಸಂಗೀತ ಬದು ಶೆಟ್ಟಿ.
ನೀವು ತಗೋತೀರಾ? ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಶ್ರೀಮತಿ
ಸಂಗೀತ ಭದ್ರ ಶೆಟ್ಟಿ.
ಸಂಗೀತಾ ಭದ್ರಶೆಟ್ಟಿ undertakes to appear for respondent number 2. Full stop. Learned counsel for the appellant is directed to serve copies of the appeal memo
Yes, sir.
along with annexures on learned counsel for respondent number 2. Next para. Learned counsel for the appellant has filed a memo seeking dispensation of notice to respondent number 1 on the ground that the liability has been fastened on respondent number 2 insurance company. Full stop. At the risk of the appellant, notice to respondent number 1 is expense. Yes.
Serial number 27, KM Kate.
Appear for appellant, plaintiff's appeal. Suit for declaration and rectification are what which came to be dismissed, my lord. There is a delay of 6 days in filing the appeal. Twenty-seven.
Issue notice to the respondents on the appeal as well as IA number 1 of 2024.
Serial number 28, Sudhir Singh R. Bijapur.
Appellant, my lordship. The is a case of uranium project, my lordship.
Huh?
Uranium project.
Huh?
We have already deposited and withdrawn the claimants are rupees 5 lakhs per acre along with the consequential benefits match. Already we deposited.
You deposited.
The claimants are withdrawn the amount.
Huh?
So 8 lakhs is awarded by the reference.
Huh?
So now it is to be under challenge.
ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ.
This under court has already
ಕೊಡಿ.
stayed the we deposited the amount on 11/1/2022 months.
But ಆ ಕೇಸಲ್ಲಿ there was a direction that you should deposit 50%.
ಅವ್ರೇನಿದೆ appellant ಅಪೇರ್ ಆಗಿದ್ರೆ
ಗೊತ್ತಾಯ್ತು. There was a direction that you will deposit 50%, but you did not deposit, but you said 8 lakhs have already been released to the claimant.
Please,
And
5
therefore,
lakhs.
there is no question of depositing 50%.
No,
That is why this order was passed.
please.
Here, we are not going to pass any such order. We are not going to direct you to deposit 50%. All right? Issue notice to the respondents.
5 and 7 government words.
To response number 1 to 5.
1
1
to
to
5,
4.
I take out notes.
Learned government advocate takes notice for response number 5 and 6. Learned counsel for the appellant is directed to serve 2 sets of copies of the appeal memo along with annexures on the learned government advocate. Full stop. Next para. Learned ನೀವು Deputy Solicitor General ಅಂತನಾ?
DSG.
You are appearing as Deputy Solicitor General. Matter. Learned Deputy Solicitor General of India, appearing on behalf of the appellant, submits that in similar matters, this court has stayed the impugned orders including the case in MFA 200-480 of 2024. Full stop. However, it is submitted that though there was a direction initially that the appellant shall deposit 50% of the award amount, nevertheless, it was later pointed out that the award at the rate of rupees 8 lakhs per acre have already been released to the
5
claim-
lakhs. 5 lakhs. 8 lakhs is awarded, we deposit the 5 lakhs.
At the rate of rupees 5 lakhs have already been
Deposited.
deposited by the appellant
11/1 to 22. 11/1
on 11/1
2022.
2022. And therefore, the appellant contended that there was no need to deposit 50% of the award amount. Full stop. The same was taken note of and liberty was reserved to the claimants to file necessary application if they were aggrieved. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned judgment and award in LAC number 5 of
5 of
2014,
14.
passed by the learned senior civil judge and JMFC at Shahpur, till the next date of hearing. Full stop. ಏನಂತ ಹೇಳಿದ್ರೆ ಲಿಬರ್ಟಿ ಇಸ್ ರಿಸರ್ವ್ಡ್ ಅಂತ ಹೇಳಿ ಟು ಫೈಲ್ ನೆಸರ್ ಅದು ಇದ್ರಲ್ಲಿ ಬಂತು ಇದ್ರಲ್ಲ ಬರ್ಕೊಳ್ಳಿ ಇವಾಗ. Needless to observe that if the respondent claimants seek deposit of any further amount at the hands of the appellant, necessary application can be filed.
CL number 29, Mrs. Aspalli.
I am a respondent in this.
On behalf of Aspali Maradise, expire against some
Huh?
Is a relative saying expire against next week and chest.
At the request of learned counsel for the appellant, release this matter on 23rd of October.
I am respondent. Respondent in this.
Yes.
Withdrawal deposit.
CL number 30, Shivanand Patil.
In filing the appeal notes,
Huh?
it's a delay.
So notice has to go.
Yes.
Issue notice on the appeal as well as IA number 1 of 2024.
CL number 31, Shivanand Patil.
This appeal also, there's a delay of 472 days. Notes. In fact,
Already matrimonial case tane idu.
yes, yes.
Appeal is filed by whom?
Appeal is filed by husband.
Husband.
Husband, my lords.
What is the?
Challenging the
what is
order of
judgment?
compromise.
Huh?
Challenging the order of compromise. In fact,
Compromise.
yes, my lords, divorce was filed, petition was filed by wife.
ಆಯ್ತು.
And during
31
the-
ಅಲ್ಲಿ
ಇಲ್ಲ 30 ಅಲ್ಲಿ appeal is filed by wife. 30 ಅಲ್ಲಿ
31 ಅಲ್ಲಿ
31 ಅಲ್ಲಿ appeal is filed by husband.
husband.
Yes, my lords.
What is the judgment there?
Lords, it was a compromise between the parties.
ಎರಡರಲ್ಲೂ ಕಾಂಪ್ರಮೈಸ್
ಇಲ್ಲ 30 ಬೇರೆ 31 ಬೇರೆ.
30 ಇದೆಯಲ್ರಿ ಮೊದ್ಲು
30 ಅಲ್ಲಿ lords, she has been placed ex parte.
ಹಾ
She has
ವಾಟ್
been
ಇಸ್ ದಿ ಜಜ್ಮೆಂಟ್?
judgment. The year 2022, while
30
filed the
appeal is filed by the wife.
ಇಲ್ಲ in serial number 30 ಅಲ್ಲಿ appeal is filed by wife, the petition is filed by husband for divorce.
ಡಿವೋರ್ಸ್ ಗ್ರಾಂಟ್ ಆಗಿದೆಯಾ?
Divorce grant ಆಗಿದೆ. She has been
ಮತ್ತೆ?
placed ex parte ಅದ್ರ.
ಹಾ
She is placed ex parte.
ಸೊ ಯು ಡೋಂಟ್ ವಾಂಟ್ ಆರ್ಡರ್ ಆಫ್ ಸ್ಟೇ?
I do want, my lords, because there was a ಅಲ್ಲ ಅದರಲ್ಲಿ ಡಿಲೇ ಇತ್ತು. Delay of
ಇರ್ಬೋದ್ರಿ, ಡಿಲೇ ಇರ್ಬೋದು.
my
ಯಾವಾಗ
522 days.
ಡಿಲೇ?
522 days ಇದೆ.
522 days
My respect
ಆಗೋಗಿದೆ ಆಗ್ಲೇ. ಅವ್ ಮೋಸ್ಟ್ಲಿ ಮದುವೆ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿರ್ತಾರೆ
ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. That is my respectful submission. So
ಅಷ್ಟೇ. ಆಲ್ ರೈಟ್.
Bill number
ಅದೇ order.
31.
in so far as 31 is
ಏನ್
concerned,
ಹೇಳಿದೆ? ಅದೇ ಆನ್ ದಿ ಅಪೀಲ್ ಆಸ್ ವೆಲ್ ಆಸ್ ಐ ನಂಬರ್ 31 ನಲ್ಲಿ
31 ನಲ್ಲಿ
ಸೇಮ್ ಆರ್ಡರ್,
this appeal is filed by husband.
ಸೇಮ್ ಆರ್ಡರ್.
Preliminary matters.
You should be careful.
Yes.
In-
Lords, since
If you are challenging a judgment of divorce, even if there is delay, you should ask for an order directing him not to get remarried.
please. Yes. Since there was a delay,
That submission can be made if there is a short delay.
yes. My only concern was, since there was a delay of 500 plus days, I had also advised my client that there is least possibilities, lords, he would have got married during that period also.
No, even otherwise, if you could make a statement
Yes.
that as per your information, till date he has not got married, then you should ask for such an order.
Yes. Only after marriage, my lord, she came to know about the judgment of the trial
He
court.
has got married.
Yes, my lord.
Okay.
Only after the marriage she got to know
Yes.
about the marriage. Please.
Preliminary matters. Bill number 32. Ramachandra K.
Matter is called out. There is no representation for the petitioner complainant. Release this matter on 22nd of October.
Bill number 33. Prakash Jadhav.
I beg your lordship's pardon. Serial number 31, if I am additionally permitted to serve hand summons on the respondent, my lords. 31 ali.
The appellant is also permitted to take out hand summons to the respondent.
Obliged.
Yes.
Seal number 33. Prakash Jadhav.
Well, I'm seeking 1 week time. The petitioner on record was not feeling well.
At the request of learned counsel for the petitioner, release this matter on 24th of October.
Admission matters. Seal number 34. Venkatesh C. Mallabadi.
Husband have filed,
Huh?
husband has filed divorce,
Huh?
divorce ಆಗಿದೆ.
Matter is called out. There is no representation for the appellant. Release this matter on 24th of October.
Seal number 35. DP Ambekar.
Matter is called out. There is no representation for either of the parties.
This one, 2 and 3.
Deputy learned government advocate. Release this matter on 25th of October.
Seal number 36. Arun Kumar Amargundappa.
My lord, may I request 24th or 25th,
25th ಬೇಡ,
please?
28th. ಅಲ್ಲ, previous matter. Previous matter 28th.
Serial number 36.
Seal number
Ah.
36.
I appear for petition. Appellant. May I request, my lord, a week's accommodation, 28.
ಏನ್ರಿ ಅಡ್ಮಿಷನ್ ಬರ್ತಾ ಇದೆ, ಏನಕ್ರಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳ್ತೀರಾ?
It is, my lord, matter pertaining to, my lord, bank transaction, that is extension of OTS period.
Ah.
Whether it is, that is the only, my lord, issue involved. Recently, my lord, Kerala High Court has taken different view following Arvind electrical case, my lord. Therefore, I will just lay my hands and make my submission.
At the request of learned counsel for the appellant, release this matter on 24th of October.
Please. Great.
Serial number 37, Manvendra Reddy.
Lord, my land has been utilized by the municipality and farmed and no compensation is paid.
What happened before the learned single judge?
Learned single judge, my lord, without, there is a disputed fact. Reject madam. Once. Para 5. In the light of the submission made by the learned counsel appearing the parties are taking into consideration the factual aspect on record, it is evident that respondent categorically stated that petitioner himself has demolished the property belonging to him, and further land belonging to the petitioner were never been acquired by the purpose of fighting.
Ray, what is your contention?
My lord, after disposal of writ petition, my lord, they are made in representation along with the received instruction from the authority, my lord. They are made in representation along with their sale deed, my lord, for measurement of site, my lord. Adralli measurement ಮಾಡಿ particular word used as, may I read, my lord? Additional document. ಸದರಿ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಈ ಕಚೇರಿಯ ತಾಂತ್ರಿಕ ಹಾಗೂ ವಿಭಾಗದವರು ನೀಡಿರುವ ವರದಿ ಹಾಗೂ ಅರ್ಜಿದಾರರು ಈ ಕಚೇರಿಗೆ ನೀಡಿರುವ ದಾಖಲೆಗಳನ್ನು ಸೂಕ್ತವಾಗಿ ಪರಿಶೀಲಿಸಿ ನೀಡಲಾಗಿದೆ. ಒಂದು ವೇಳೆ ಅರ್ಜಿದಾರರು ಈ ಕಚೇರಿಗೆ ನೀಡಿರುವ ಮಾಹಿತಿ ದಾಖಲೆಗಳು ಸುಳ್ಳು ಮತ್ತು ದುರುದ್ದೇಶದಿಂದ ಕೂಡಿದ್ದು ಅಂತ ಯಾವುದೇ ಸಂದರ್ಭದಲ್ಲಿ ಕಂಡು ಬಂದಲ್ಲಿ ಪ್ರಮಾಣ ಪತ್ರ ತನ್ನಿಂದ ತಾನೇ ರದ್ದುಗೊಳ್ಳುತ್ತದೆ ಎಂದು ಷರತ್ತಿನೊಂದಿಗೆ ನೀಡಲಾಗಿದೆ. My lord, in writ petition we are taking a contention that he has to approach to the civil court.
Why?
My lord, because ಇವ್ರು ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದ್ರ ಮೇಲೆ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿದ್ದಿದೆ. This document has to prove before the competent.
You are the CMC.
Please, my lord.
The contention is that you have utilized a portion of his property for widening of the road.
Please, my lord.
If you have utilized, you'll have to pay compensation.
My lord,
That's all.
As per the instruction of the CMC, they are encroached the property of the public road, my lord. They are encroached the public road, my lord. By encroaching the public property, my lord, they are constructed.
So what action can you take?
That portion they are removed, my lord.
How?
Himself they are removed. ಇವ್ರು ಒಬ್ಬರೇ ಅಲ್ಲ ಸ್ವಾಮಿ, ಆ ಎಂಟೈರ್ ರೋಡ್ ಅಲ್ಲಿ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿ
ಬರೋದಿಲ್ಲ.
ಅದಾದ್ಮೇಲೆ
in any number of judgments we have held, this type of an action cannot be done by the local bodies, not permissible.
My lord, kindly direct the respondent authority to hold an inquiry and conduct a spot panchnama. Then if it is utilized, my lord, then they are entered.
He has produced a copy of the sale deed, title deed.
Please, my lord.
Then any portion is utilized in that property,
Please.
for liable to pay compensation.
Please.
That is all.
No, it is their
Nothing
own.
more.
To hold an inquiry and conducting a spot panchnama, my lord. If they are utilized, they are entitled.
My lord, kindly see page 63. It is their document.
ಅಲ್ಲ ಇದನ್ನೇ ಓದ್ ಹೇಳ್ದೆ ನಾನೀಗ.
ಅಲ್ಲ
63 na.
After disposal of writ petition, my lord, they are made representation before the
Yes.
authority by placing the records, my lord.
ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 233.08881 ಚದುರ ಮೀಟರ್. ಸದರಿ ಮನೆಯು ರಸ್ತೆ ಅಗಲೀಕರಣದಲ್ಲಿ ತೆರವುಗೊಂಡ ಮೇಲೆ ಬಾಕಿ ಉಳಿದ ವಿಸ್ತೀರ್ಣ ಮತ್ತೆ ಕಡಿಮೆ ಆಯ್ತು.
It is
ಅಲ್ಲ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದು based on the request and place. ಅಲ್ಲ I'll make
What kind of submission are you making, sir? Why would he request ಬಂದ್ ತಗೊಳ್ಳಿ ನನ್ನ ಜಾಗನ ಅಂತ?
ಅಲ್ಲ ಆ ರೋಡ್ ಅಲ್ಲಿ ಇರೋ ಎಲ್ಲಾರ್ದು ಇದನ್ನೇ
ಇದು ದಬ್ಬಾಳಿಕೆ ಇದು.
ಅದಕ್ಕೆ if they are
ನಿಮ್ಮ ಮುನ್ಸಿಪಾಲಿಟಿ ಅವ್ರ ದಬ್ಬಾಳಿಕೆ ಇದು.
if that was utilized, my lord.
If you are utilized, you will have to pay compensation. That is all.
Please, man.
Nothing more in this matter.
Please, man.
ಬರ್ಕೊಳ್ಳಿ.
My only submission before this honorable court, my lord. My only submission before this honorable court, my lord, to hold an.
He is encroached. They should have taken action in accordance with law. They cannot take law into their hands.
Please, man. let them hold an inquiry and conduct an spot panchnama. If it is utilized,
ಬಂದಿದ್ಯಲ್ರಿ ನಿಮ್ಮಲ್ಲೇ.
It is their own document. It is not
It is
made.
your document.
please,
Then
once again, my lord,
No.
to conduct an spot
no,
panchnama.
no. ಹಿಂಗೆ ಮಾಡ್ಕೊಂಡ್ ಬಿಟ್ರೆ ಇನ್ ಮೇನೇನ ಬೇರೆ ವಿಷಯನೆಲ್ಲ ಕೆದಕ್ತೀರಾ ನೀವು. It is a simple case of utilization of the property.
Agreed, my
for,
lord.
widening of
ಇದ್ರಲ್ಲಿ
the road.
ವರ್ಡ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ, ನೀವು ಕೊಟ್ಟಿರೋ ದಾಖಲೆಗಳ ಪ್ರಕಾರ ಇಫ್ ಇನ್ ಕೇಸ್ ಇದು ತಪ್ಪಿದ್ರೆ ಅನ್ನೋದು ಒಂದು ಬಂದಿರೋದ್ರಿಂದ
ಬಂದಿದೆಯಲ್ಲ.
ಅಲ್ಲಲ್ಲಿ ಕೆಳಗಡೆ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಮುನ್ಸಿಪಾಲಿಟಿ ರೆಕಾರ್ಡ್ಸ್ ಅನ್ನ ಟ್ಯಾಲಿ ಮಾಡಿ ನೋಡಿಲ್ಲ ಸ್ವಾಮಿ. ಓನ್ಲಿ ಇವ್ರ ರಿಕ್ವೆಸ್ಟ್ ಮೇಲೆ ಅದನ್ನ ಮೇಜರ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಅಲಾಂಗ್ ವಿತ್ ಟ್ಯಾಲಿ ವಿತ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆಫ್ ಮುನ್ಸಿಪಾಲಿಟಿ ಅಂಡ್ ಪಾಸ್ ಎನ್ ಆರ್ಡರ್ ಅಂತ
ನಿಮ್ ಮುನ್ಸಿಪಾಲಿಟಿ ಬೇರೆ ಇನ್ಫಾರ್ಮೇಶನ್.
ಅಲ್ಲಲ್ಲ ರೋಡ್ ಎಷ್ಟಿದೆ, ಎಷ್ಟು ಯುಟಿಲೈಸ್ ಆಗಿದೆ,
ರೋಡ್ ಎಷ್ಟು ಅಗಲ ಇದೆ ಅನ್ನೋದು ನಿಮ್ಮ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಇರೋದು. ಅದೆಲ್ಲ ಮುಖ್ಯ
ಅಲ್ಲ. ಒರಿಜಿನಲ್ ರೋಡ್ ಸ್ವಾಮಿ.
You have issued a khata in their name.
If it is,
it will be based on the title deed.
Please, my lord.
Isn't it? You have accepted.
Yes, my lord.
You have been collecting property tax.
Please, my lord.
Now, how can you say?
ಅಲ್ಲಲ್ಲ,
No. A portion of it is municipality property, and therefore we have proceeded to utilize it for.
ಅದನ್ನೇ ಮಾಡಿ. If it is in accordance with ಅದನ್ನ ಯುಟಿಲೈಸ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ to pay in compensation. That is only my submission.
Perfect. The petitioner, the appellant, is aggrieved of the fact that the learned single judge did not consider the grievance of the appellant in the proper perspective. Stop. The appellant had filed the writ petition alleging that the fourth respondent, City Municipal Council, Yadgir, has utilized a portion of the property belonging to the petitioner for widening the road. Full stop. However, the learned single judge dismissed the writ petition on the ground that disputed questions of fact are involved. Full stop. Learned counsel for the appellant submits that if a citizen voices a grievance against a local body that a portion of his private property has been utilized for the purpose of formation of road or expansion of road, without granting compensation or without acquiring the property in accordance with law, then this court has the necessary power under Article 226 and 227 of the Constitution of India to issue necessary directions to the local body to determine the compensation and pay the same. Full stop. Next para. However, learned counsel for the fourth respondent, CMC, points out from annexure R1, which is filed along with IA number 2 of 2023.
It is not R1, my lord, additional document.
R1 ಅಂತ
ಅದು R1 ಆಗತ್ತೆ, additional document.
ಏನ್ ಹೇಳಿದೆ? For production of additional documents, that subsequent to the dismissal of the writ petition, a representation was given by the appellant in terms of the directions issued by the learned single judge, and accordingly a certificate of measurement of the property belonging to the appellant herein has been furnished by the fourth respondent on 2/11/2023. Full stop. The representation given by the appellant has been disposed of. Accordingly. Full stop. Next para. Having heard the learned counsel for the appellant, learned counsel for respondent number 4, and having perused the appeal memo, this court has with the considered opinion that the appellant, the learned counsel for the appellant is right in his submission that this court can exercise the powers conferred under Article 226 and 227 of the Constitution of India to redress a grievance of a citizen of this country who alleges that a public authority has utilized a portion of his or her private property without acquisition, without following the process of acquisition or determining compensation or payment of compensation. Full stop. It is an admitted fact that the fourth respondent, CMC, has registered khata in the name of the appellant herein in its records and has been collecting property tax from the appellant. Full stop. It is also not disputed in Annexure R1, which is a certificate issued by the municipality, that in terms of the title deed belonging to the appellant, the extent of the property measures 233.0881 square meters. Full stop. However, after formation of the road or expansion thereof, the property now measures 178.716 square meters. Full stop. This itself shows that a portion of the property belonging to the appellant has been utilized for expansion of the road. Full stop. In that view of the matter, we do not hesitate to issue necessary directions to the fourth respondent to determine the compensation payable to the appellant for utilization of a portion of the property belonging to the appellant and pay the same in accordance with law. Full stop. Next para. Consequently, the writ appeal is allowed. Full stop. The writ petition is also allowed while directing the fourth respondent, Commissioner of the City Municipal Council, Yadgir, to proceed to once again measure the property belonging to the appellant, on the basis of the title deeds of the appellant. Full stop. Thereafter, the commissioner shall prepare a sketch to show the extent of utilization of the property belonging to the appellant towards the road. Full stop. After determination, compensation shall also be determined and awarded in accordance with law and as expeditiously as possible. Full stop. The entire exercise shall be concluded as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order.
Acquisition proceedings within 2 months, it's not.
Huh?
Acquisition proceedings within 2 months not possible, my lord. If ಉಳಿದಿದ್ದೆಲ್ಲ process 2 months ಅಲ್ಲಿ complete ಮಾಡಿ, let them start the acquisition proceedings.
ಎಷ್ಟು ದಿವಸ ಬೇಕು ನಿಮ್ಗೆ?
Acquisition minimum 6 months ಬೇಕು ಸ್ವಾಮಿ.
ಹಾ?
Acquisition proceedings ಮಾಡೋದಕ್ಕೆ minimum 6 months ಬೇಕು ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ preliminary notification ಆಗ್ಬೇಕು, final notification ಆಗ್ಬೇಕು, award ಆಗ್ಬೇಕು. It will take time.
ಆ ರೋಡ್ ಅಲ್ಲಿ ಇರೋರು ಎಲ್ಲಾರು ಬರ್ತಾರೆ ಈಗ. Additional. IA number ಕೆಳಗಡೆ IA number 2 of 2023 is also accordingly allowed. The entire exercise of determining the compensation shall be concluded within a period of 2 months from the date of receipt of a copy of this order. Full stop. However, since the process of issuing a notification and payment of the compensation may take a longer time, comma, the other process shall be completed within a period of 6 months.
Please. Obliged.
Year number 38, Shivanand Patil.
My lord, in this case, I am for the curator, my lord. My learned
Last
friend-
IA allowed anta last law. Yes.
My lord, in this case, I am for the curator.
Partition and separate position.
Curator, my lord, yesterday my learned friend served a copy. I pray for 2 weeks time to file my objections to this IA, my lord. IA first.
Learned counsel for the
Going of
respondent.
the final decree may be still, I'm not asking for any specific order.
Partition
Drawing of
should-
the final decree, partition
Petition.
should be just.
Submits that the learned counsel for the appellant has served copy of IA number 1 of 2021 and 2 of 2024. ಯಾವಾಗ ನೆನ್ನೆನಾ?
ಹೌದು ಸರ್, ನಿನ್ನೆ ಮಧ್ಯಾಹ್ನ ಸರ್ ಮಾಡಿದ.
Yesterday. And therefore, the learned counsel prays for some time to secure instructions and make submissions or to file objections. Full stop. Next para. However, learned counsel for the appellant submits that the appellant is before this court aggrieved of the impugned judgment in a suit for partition
Partition and separate.
and separate possession. And therefore, the trial court may be directed not to draw the final decree during the pendency of the appeal. Full stop. Next para. Accordingly, the trial court is directed not to proceed to draw the final decree, comma, without specific directions of this court.
Notice. Yes, taken.
ತಗೊಂಡಿದಾರಲ್ಲ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ learned counsel Shri Ravindra DK has entered appearance for response number 1 and 2.
1 and 2.
ಅಷ್ಟೇನಾ? For both the respondents.
Yes.
For both the respondents.
Seal number 39, Kausalgi Chandrakant Lakshman.
Release this matter on 24th of October.
My lord, 24th, 25th, my lord.
Serial number 13.
ಅಲ್ಲ ನಿಮ್ದಲ್ಲ next matter ಅದು.
Okay.
Yes.
Final hearing matter, serial number 4040, Narendra M. Reddy.
Matter is called out. There is no representation for either of the parties. Release this matter on 24th of October.
Serial number 41, Vinayak Apte.
My lord, I appear for respondent in one case and appellant in the cross objection.
Matter is called out. There is no representation for the appellant in RFA 2000088 of 2016. Full stop. Release this matter on 24th of October.
My lord, 23 to 25
And,
conveys.
28th of October.
Please,
Seal number 42, Ashok Patil.
in this case, I pray for a week's accommodation, my lord.
At the request of learned counsel for the appellant, release this matter on 29th of October.
Please.
Seal number 43, Ajay Kumar AK. Virnugoda Mali Patil.
Matter is called out. There is no representation for the appellant. Release this matter on 4th of November.
Please.
Seal number 45, Chambulinge Salimat.
The matter is called out. No representation for the appellant. Release this matter on 4th of November.
Seal number 47, Sanjeev Kumar C Patil. 47,
Lord, I look for the appellant.
Appellant.
Appellant, Lord. 1 week's time, Lord, I will get ready and
At the request of learned counsel for the appellant, release this matter
on 29th or 30th.
on 29th of October.
seal number 48, BC Jaka.
So 302. The appeal against conviction.
Called out. No representation for the appellant. Release this matter on 5th of November.
Please.
Seal number 49, Ramaswamy Manjunath, Ramesh Verma M.
I appear for respondents.
Lord, kindly pass over, my lord. Sanjay Kulkar, kindly pass over, my lord. Sanjay Kulkarni is in
The
another
request of
portal, my
learned
lord.
counsel for the appellant, release this matter on, you want it on 23rd?
Yes.
23rd of October.
In fact, last date of hearing, my lords, I filed an application for police protection. It was adjourned, my lords, on the 3 times it was adjourned on the request that it will be heard and not disposed of. Since that is the, my lord, submission made by the
You
other.
are seeking police protection.
Also, our undertaking ಕೊಟ್ಟಿದ್ರು court ಮುಂದೆ ಅದು ಅಯ್ಯೇ ಪೆಂಡಿಂಗ್ ಇದೆ ಇನ್ನು. Based on their undertaking only.
ಏನ್ ರೆಕಾರ್ಡ್ ಮಾಡಿಲ್ವಲ್ರಿ?
ಲಾಸ್ಟ್ ಡೇಟ್ ಇದೆ ಬಂದಿತ್ತು. It has been recorded.
25/9
ಹೌದು.
In fact, it requires
25/9/2020.
It requires hearing, my lord. In fact, we are ready. Last occasion did not reach to advise, my lord. So. Police protection for what?
My lords, I filed a suit for declaration and permanent injunction. During the entire my lords, proceedings before the trial court, I had a benefit of injunction order. And finally, the court has decreed and also granted permanent injunction. And there was admission also given by the DW 1 and 2, my lords. I am in the possession of the property, and even they tried to, my lords, evict me from the interference they have caused in the property, suitable property that has been, my lords, protected during the court proceedings. Then, my lords, when the appeal is filed before this court, my lords, and there was an
Filed a suit for declaration and injunction.
Injunction, permanent injunction.
It has been granted.
And the entire suit
Now you
proceedings.
need police protection to ensure that there is no interference at the hands of the
Interference. Then, my lords, when I filed an police protection at initial stage, my lords, then they appeared and they ensured before the undertaken is given before the court that they will not interfere, my lords. Alli. Thereafter, once again, they interfered in the peaceful possession and I approached the jurisdictional police. The jurisdictional police issued the endorsement stating that since the matter relates to civil dispute and the RFE is pending, therefore they will not interfere. Again, that, my lords, I filed a second application for violation.
In fact, in first occasion, my lords, while granting interim order of this honorable court,
there itself it has been mentioned, my lord, it is as good as not present. Because, my lords, it is undertaking from the both side will not interfere. In the same time, my lords, in fact, my
It
lords,
has been recorded, is it?
yes, my lords. It is order dated, my lords. In the application filed by the other side, my lords, in page 64, 63, it starts, my lords.
It's order dated, my lords.
64. IA number 3 of 2023, my lords. In fact, my lords, it requires hearing, my lords, because the other,
Despite this order, if you are trying to do something,
definitely
it will
not,
amount to
my lords.
contempt.
In the same time, my lords, what happened, my lords? Other side also make a representation to the revenue authorities for converting, my lords, entries.
Direction ಇದೆಯಲ್ಲ ಇಲ್ಲಿ. They
ಇಲ್ಲ,
cannot
ಅವ್ರು
do
en-
it.
From the both sides should maintain the
ಮಾಡಕ್
status.
ಬರೋದಿಲ್ಲ sir, there is a direction.
True, my lord. We are not in.
ಅವ್ರೇನಾದ್ರು despite that, if they do something,
Yes,
you come before this court. ಅದನ್ನ ಹೇಳಿದ್ದಾರೆ.
ಅದು ಹೇಳಿದ್ದಾರೆ. That's what my submission. That is the reason it may be taken on merit, my lords, final hearing itself. It will be over otherwise because.
No.
Uh,
Despite this, if you try to interfere,
we are not in.
then it will amount to contempt.
True, my lords. That is
They are
the.
asking for police protection on the ground that you are still trying to interfere.
My lords, my submission would be, my lords. In fact, they are also trying to make, my lords, representation to the revenue authorities. I got a copy.
ಮತ್ತೆ ಅದೇ ಹೇಳ್ತಿರಲ್ರಿ. Is there any meaning in that one?
True, my lords.
There is a direction, clear direction here.
Yes.
So if the revenue authorities do something, it will be in contempt.
True, my lords.
Let them do, we'll see. On that ground, you cannot try to interfere, sir.
Please, earlier occasion also, my lords, twice is rejected, my lords. IA number 1 of, my lord, 3 of 23, lordship, may kindly see.
Order on IA number 1 of 2024. This application is filed by the respondent alleging interference at the hands of the appellant despite specific directions being issued by this court.
May I make a one submission? May I make a one submission, lords?
By order dated 30/5/2023, that the appellant shall not use the said order to create any untoward incident near the suit schedule property. Full stop. Next para. Per contra, learned counsel for the appellant submits that there is also a direction issued by this court that the status quo regarding revenue entries shall be maintained without prejudice to the appellants who have secured loan on the basis of the suit schedule property. Full stop. ಏನಂತ ಹೇಳಿದೆ? Full stop. And despite such directions, efforts are being made by the respondent to change the revenue entries. Full stop. Next para. In the considered opinion of this court, when there is a specific direction issued by this court that revenue entries shall not be changed during the pendency of the appeal, any attempt made by the respondent to change the revenue entries would amount to contempt. Full stop. At the same time, the appellant also cannot do anything that would give rise to a situation where the respondent would allege interference at the hands of the appellant. Full stop. Next para. Therefore, in view of the specific directions already being given by this court by order dated 30/5/2023, this application stands disposed of while directing both the parties to ensure compliance of the order dated 30/5/2024. Full stop. The parties should also take note of the fact that this court has directed that if for any reason, any directions are required to be issued by this court, the parties have to file necessary application and shall not go against the orders passed by this court. IA accordingly disposed of.
But if there is any police, if there is there any violation of causing interference, I may be given
You have
liberty
to file it along with proper evidence.
I have filed it.
Let us see.
I have filed it along with photographs,
Right.
complaint and everything.
Huh?
I have
So
filed
we have
it.
issued directions now.
Hmm.
It would amount to content with that if they do that. If they do it again, you please file it and we will proceed to take action against them. Yes.
But it may be taken on 23rd for hearing. 23rd, because already paper books and everything are filed.
ಹಳೆ ಮ್ಯಾಟರ್ ಬಹಳಷ್ಟು ಇದಾವೆ.
Also, I will undertake, my lords, in fact, that application, what they are alleging is that we try to not change the revenue entries.
ಮಾಡಕ್
In fact-
ಸಾಧ್ಯನೇ ಇಲ್ಲ.
ಇಲ್ಲ ಅದಕ್ಕೆ we will undertake, my lords, we will not do anything.
Go and show this order to the revenue authorities.
That will do.
Yes.
That's why, my lords, I am requesting that now what happened is, my lords, there were 4 complaints were filed. They are continuously interfering in the peaceful possession. We are, my lords, not in a position to cultivate the lands, and now it is required, my lords, we have to pesticides and other things, we have to do it. There were several times attempts were made, my lords, and police came to the spot, and there were photographs are produced, and there are 4 complaints were filed, my lords, and several times they have issued the endorsement on the same ground. That is why we forced to file the, my lords, second application. Otherwise, we would have not filed the application for second time. After undertaking, they do it again, my lords.
Entire property, my lords,
Paragraph ಇನ್ನೊಂದು ಬರ್ಕೊಳ್ಳಿ.
entire property stands in the name of temple.
Despite the said order, if the appellant seeks to cause any interference in the suit schedule property, the respondent is also at liberty to bring the same to the notice of the jurisdictional police. Full stop. The jurisdictional police are also hereby directed to take note of the orders passed by this court and ensure that there shall be no interference at the hands of the appellant. In violation of the orders of this court.
My submission, my lords. In fact, my lords, virtually this order, my lords, they may misuse it, my lords, because
What misuse?
it's in the
ನೀವು
hands
ಅಲ್ಲಿ
of.
ಹತ್ರ ಹೋಗದೆ ಇದ್ರೆ
ಏನಾಗಿದೆ, I'll just mention it, my lord. Entire property stands in the name of temple, my lord, by virtue of Assistant Commissioner order.
we can't go back on all those things, sir. There is already an order
Yes,
passed on 30th of May.
Virtue of this last order, my
It's-
lord.
There is a clear direction that you shall
That
not
will obey
interfere.
it, my lord.
So
By
don't
virtue of,
interfere.
if it is
Don't
given,
interfere.
please.
Yes.
C number 50, Girisham Patil.
Sole accused against conviction.
Huh?
Sole accused, my lords.
C number 50, Girisham Patil.
Matter is called out. There is no representation for the appellant. Release this matter on 6th of November, please.
C number 51, Rajesh Doddamani.
For a week's time. I prefer that.
22.
Yes.
Release this matter on 7th of November.
Great.
C number 52, Sandangoda V. Biradar.
My lord,
for respond number
claimant's
2.
appeal, my lord, seeking for enhancement. This is a claimant's appeal, my lord, seeking for enhancement. In this case, my lord, the deceased one, Dilip, was doing a one business. There is a bar and restaurant, and he was produced, my lord's income tax returns. He was himself doing the business of bar and restaurant. Yes, my lords. My lords, he was produced, my lords, IT returns as per exhibit P11. License of the shop is produced, my lords, P12, my lords. Yes. And the criminal, I'm showing my income in the year 2017-18, that is, my lords, 5,91,000, and 18-19, 12,08,000, and 19-20. 17-18, 5,47,512. 5,47,512 after the deduction of income tax, my lords. After the reduction of income tax is 5,47,512. And 2018-19, 10,28,279. The 19-20, 8,40,000. We are produced the income tax returns. The tribunal, my lords, the taken by income is only, my lords, 20,000. 20,000 is taken. Considered by the tribunal. In 20,000 per month. In Impekar eshtagutte? My lords, my submission is that, my lords, he was the petitioner number 2. In evidence, he was saying that, my lords, liquor shop, he was given rent and he received 10,000 rupees per month from the shop, my lords. As per the evidence. He was receiving only rents. Rent. He was not running the. He was not running. No, he was not running because that's the reason, my lords. My submission is that, my lords, even though, my lords, the 10,000 is deducted, then also, my lords, it's come, my lords, on submission, my lords. 36. My lords, on submission, my lords. What has happened, my lords? License was not surrendered, my lords. Bar license, my lords. Hence, the tribunal has considered 13,250 per month. It should have been considered as per the chart, my lord, as per Lok Adalat chart, my lord. But why Lok Adalat chart? Because, my lord, he has not surrendered the license, my lord. Bar license, my lords. Bar license, which he was earning through the license, my lords. He was holding bar license, my lords. He has not surrendered after the death of the Dilip, one deceased, my lords. The family is carrying on that business, my lord. So there is no loss of earning capacity will not affect, my lord. Only that has to be considered by the tribunal, my lord. That was considered, my lords. And 20,000 exceeding that also, honorable tribunal has considered 20,000, my lords. And now it is already a higher side compensation has been awarded, my lord. Now the question of taking consideration of IT returns will not come into the. That is my submission, my lords. Even tribunal has also made same. How it should be calculated in these circumstances? My lords, because license is not surrendered, my lords. Correct. Yes, my lord. How it should be considered? 20,000 has been considered by the tribunal, my lords. How? What is the basis, sir? Guesswork. Yes, my lord. That is. Is there no Supreme Court judgment as to how it should be done? No, but there is local when there is no loss of earning produced by any document, my lords. Then the question of as per local chart, they have to consider, my lord. ಯಾವ judgment, sir? No, my judgment. It is not judgment, my lord. Local chart has been taken for. We are not able to understand. It is understood. Yes, that it is a family business. Yes, ma'am. So even after the death of this person, yes, the business is continuing. Yes. So there is no loss of income as such. Yes, ma'am. Under those circumstances, yes, how the compensation has to be determined? Notional income. What is which judgment, sir? Torsi, how the judgment? Judgment is not. Why? Judgment. Because, my lord, loss of. Don't need any judgment for that. My lord, there is necessary, my lord. So we are asking you. You may be well versed with this subject. No. We are asking you. Let us see what is the ruling of the Supreme Court. Yes, my lord. Only managerial post, my lords. I will see which is that judgment. A week time. ಅಥವಾ ನೀವು ಇದ್ರಲ್ಲಿ ಈ impugned order ಅಲ್ಲಿ ಅದ್ರ ಬಗ್ಗೆ reference ಇದ್ರೆ please point out. No, my lord. A week's time may be granted, my lord. I will produce that. ಬರ್ಕೊಳ್ಳಿ. the, huh? So what would be the contribution of the deceased person to the family
Yes, my lord.
towards the income of the family?
Yes, my lord. Only I'll produce that. Only his loss of dependency will come arise only to the extent of managerial post, my lord. Because he was carrying the business as a manager post, and the business is still entity is still carrying out the business, my lord. Only the managerial post that I'll make submission on that judgment I'll produce.
The learned counsels are required to point out to any judgment which deals with a situation where, despite the death of the person, the family business continues and there is no decrease, there is no change in the income derived from the family business. Full stop. But under such circumstances, what is the manner in which the compensation has to be determined? Full stop. Next para. Release this matter on 23rd of October. Yes.
As per parted my lords, ಮೇಲ್ ಬರುತ್ತೆ.
ನಮ್ದಲ್ಲೆಲ್ಲ ಫೈನಲ್ ಇಯರಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಲಾಸ್ಟ್ ಅಲ್ಲೇ ಬರೋದು. Anyway, we are reaching all the matters. What is the difficulty? Pass over ಏನಿಲ್ಲ.
One submission. May I make one submission?
Yes.
Serial number 40 minutes. I seek apology minutes. I was filled up. In that minutes, I appear for the appellant minutes. Sole respondent has expired minutes.
Huh?
Sole respondent has expired minutes. There is no date minutes. Serial number 40 minutes. 40. I appear for the.
Need to file application.
Yes, minutes.
Serial number 40. Learned counsel for the appellant.
More than 90 days have been passed minutes already.
That the sole deceased respondent is no more.
Please.
And therefore necessary applications will have to be filed to bring the legal representatives on record.
Please.
Full stop. 2 weeks are granted to do the need.
Please.
ಫೋನ್ ಮಾಡಿ ಆಮೇಲೆ ತಂದು ಇರ್ತೀನಿ. ಎಲ್ಲಿಂದ ಬಂತು ಅವ್ರು ಸಾಹೇಬ್ ಜೊತೆಗೆ ಬರ್ಲಿಲ್ಲ ಸರ್ ಅವರು. ಮತ್ತೆ ಅಮ್ಮ ಫೋನ್ ಮಾಡ್ತೀನಿ ತಂದು. ಸರಿ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ? ಇಲ್ಲ ಅದು ಇವ್ರಿಗೆ ಈ ತೊಗೊಂಡು ಹೋಗ್ತಾನೆ ಆ 7ಗೆ ಕೋಟಲ್ ಸೇವಾ ಹೊಸರಾಜ್ ಸಾಹೇಬ್ರು ಚಿನ್ನದ ರೇಟ್ ಹೋಗಿ ತೊಗೊಂಡು ಹೋಗ್ತಾರೆ. ಅಲ್ಲೇ ಹೇಳ್ರಿ ಇಲ್ಲಿ ತಲೆ ಹೇಳ್ರಿ. ಹೌದು ಅವ್ರ ಜಮೀನ್ದಾರ್ ತಂದೈತೆ. ರೈಟ್ ಆಯ್ತಾ.
Matters pertaining to principal bench bank. Serial number 1, Shankar.
It's appearing on behalf of the petitioner in WP number 24572 of 24 minutes.
Yes.
First matter.
Madam, what applications they have moved and why they have moved, nothing is informed to us. We are totally in dark, Lord.
Lords,
Not
everything
even
is served on
one
them.
of the matters. Absolutely no, my lord. Ready to file an affidavit as a senior counsel, I can do that. If my learned friend dispute.
No, my lord, even I have been informed by my instructing counsel that no copy of any of the
No copies are served. How IS are put up by before the court. Certainly we are surprised and shocking also.
Lords, my instruction is that we have
That
served
they
the
can serve instead of that they can brought us in by day light.
All right, you please serve copies on them.
I shall do that, my lords. My lords, I really failed because my instruction is that it has been served. But if the senior counsel is saying that the copies is not served, I don't want to dispute the sentence, my lords. I will not
No, it is
dispute
not.
this.
No, it is not served, my lord. Even I will.
We will have it on Monday.
Lordships, Monday at 1 o'clock, my lords. Monday at 1 o'clock or 2:30 minutes. At any time, my lords. What your
Monday we will have it at 4 o'clock.
Very well, my lords. I'm grateful. I'm grateful.
All right.
Please, please.
Release this matter. These matters on 21st of October 2024 at 4 p.m.
Please, my lords. I'm grateful.
Very well.
My apologies, my lords, if there was some inconvenience caused to the court because of this.
That they can serve. I request my revision court to serve the copy well in advance.
Learned counsel for the petitioners is requested to serve copies of the interlocutory applications on the learned counsels for the respondents.
Please, my lords.
Both matters.
ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡ್ಬೇಕು ಇಪ್ಪತ್ತೊಂದು ಡೇಟ್ ಇದೆ 4 ಗಂಟೆ ಗಂಟೆ ಮುಂದೆ ಬರೋದು ನೆಕ್ಸ್ಟ್ ಏನಂತ ಉಸ್ಮಾನನ ನಮ್ಗೆ ಮಾಡೋದು ಸೇಮ್ 21st 4 PM அந்த ಅಪ್ಲಿಕೇಶನ್ ಸರ್ವ್ ಮಾಡಬೇಕು ಅಂತ ಯಾರು ನಮ್ಗೆ ಯಾರು ಮಾಡೋದು ಉಸ್ಮಾನ ಬಾ ಅಂತ ಹೇಳಿ ಫೋನ್ ಹಿಡಿತೀನಿ ಹೇಳೋಣ ಮತ್ತೆ ಫಸ್ಟ್ ಸಿಂಗಲ್ ಮಾಡೋದು